All right. Very good afternoon, ladies and gentlemen. Thank you for logging onto this webinar session. We are excited to host you this afternoon. As you join, we kindly request you to tell a friend that we have started. And let's give this 2 minutes and then we start. We have our panelists already waiting to present, and we look forward for you this afternoon. I'll be back in 1 minute to introduce the moderator and then we'll kickstart the session. Thank you so much. In the meantime, let's get tweeting, let's get sharing the webinar flyer, let us get watching on Facebook and on YouTube where we're streaming live. Good afternoon. A very good afternoon, ladies and gentlemen. Welcome to this East Africa Law Society webinar session discussing emerging trends in patent, trade right, trademark and copyright, and trade secret holders in East Africa. This afternoon, we are honored to be joined by a distinguished panel of people who have taken time and specialized in this area of intellectual property. Without further ado, ladies and gentlemen, allow me to introduce our moderator, Miss Josephine Oyombe, who is a highly experienced intellectual property lawyer with over 12 years of experience in this field. She's represented numerous clients in the technology industry, including startups. She's established various companies and she's worked with various local celebrities and music bands within Kenya and generally in the creative industry. She holds a Master's of Law degree in International Trade and Investment Law from the University of Nairobi. She holds an LLB from Moi University and a postgraduate diploma in legal practice from the Kenya School of Law. She's a she's a copyright certificate offered by Harvard X, a branch of Harvard University. She's a certified public secretary, which qualification she got from the Institute of Certified Public Secretaries of Kenya, and a certificate in senior management training in the Kenya School of Government. She's a trained and certified mediator and mediation training under the Mediation Training Institute. Mr. Yombe, it's my pleasure to have you this afternoon. And thank you so much for agreeing to moderate this session. I'll now hand it over to you to take on the discussion.
Thank you so much, Gabriel, for that introduction. So I am pleased to welcome all of you for this exciting webinar that we have this afternoon. So the topic that we shall be considering today is the emerging trends affecting patent, trademark, copyright, as well as trade secret holders when it comes to the emerging trends in technology. So today we have quite a great panel, a panel that is very well informed when it comes to the topic that we are handling today. So I will just go through the profiles of the list of the panelists that we have, and thereafter we shall delve into the presentations that they have for us in terms of the exciting topic. So while they do their presentations, for the people listening in, should you have any questions, we will be excited to take them after the presentations are done. So in the meantime, you can just post your questions where there's a section written Q&A. So if you have any questions as the presentations are done, not to post your questions there, and we shall consider them after the presentations. So our first panelist of the day is Miss Eileen Aluso. So Eileen is an advocate of the High Court of Kenya. She has over 7 years post-admission experience, and she's currently pursuing a master's in intellectual property law at the University of Dar es Salaam. She is a former managing partner at Kazi Advocates LLP, and she has had an extensive experience relating to intellectual property rights and litigation, intellectual property audits, regulatory and aspects of innovators, as well as she has served as a council member at the Law Society of Kenya for over a period 6 years, during which period also a patent agent registered at the Kenya Industrial Property Institute from the year 2016 to date. She has handled applications for registration and renewal of trademarks, industrial designs, utility models, patents, and she has experience in drafting and reviewing technology transfer agreements, terms and conditions on respective websites, copyright litigation, among other matters. So she hasn't joined us yet, but she'll be able to say hello once she joins in. So moving on to our second panelist, we have Mr. Mkama Kalebu. Mr. Mkama Kalebu is the managing partner and the head of intellectual property, technology and media telecommunications and data protection practices. He handles both contentious and non-contentious matters in the areas of intellectual property, media, information and technology, data protection, telecommunications law, amongst others. He has extensive experience working on regulatory transactions, enforcement, and advisory projects among his clients, who consist of multinational companies. So he is an advocate of the High Court of Tanzania and other subordinate courts there too. And again, he is also a member of the East African Law Society, a member of the Tanganyika Law Society, and a member of the Zanzibar Law Society. He is also a notary public and a commissioner of oaths in Tanzania. Mr. Mkama formerly trained and practiced at the Office of the Attorney General of Tanzania, and he also previously worked at Mkono and Company Advocates as an intellectual property trainee, associate, and later as an intellectual property associate. So, Mr. Mkama, maybe you can just say hi. You can unmute your video and say hello to our listeners.
Hello. Hi, everyone. have you today, and we hope we shall be having a good and wonderful session. Thank you.
Okay, thank you so much for that. So we proceed to the third panelist that we have present with us today. We have Mr. Pius Ntazinda. So Mr. Ntazinda is a lawyer and a managing partner at CM Advocates Rwanda. He holds a Bachelor of Laws degree from the University of Rwanda and a postgraduate diploma in legal practice from the Institute of Legal Practice and Development, Rwanda. He has received training from WIPO, RIPO, USPTO, among other IP organizations. His practice focuses on intellectual property, technology, and general corporate law. He is an advocate licensed to practice law in Rwanda and a member of the East Africa Law Society, where he's a member of the IP committee. So additionally, Mr. Ntanzinda is a tech enthusiast, being a member of the Africa Legal Tech Network, Innovation Law Club Africa, and a founding member of the Rwanda Blockchain Association. He is a native speaker of Kinyarwanda and has excellent command of English and a working knowledge of French, among others. So, Mr. Pius Ntanzinda, welcome. You can just unmute your mic and video and say hello to our listeners.
Hello, everyone. Good to be with you. Surprised my profile says I have an excellent command of English. Don't know about that, but happy to be with you all. Thank you.
Okay, you're welcome and thank you so much. So we proceed to the fourth panelist that we have with us today. I'm not sure if he has joined us yet, but he will be joining us as we proceed. So this is Professor David Bakibanga. So Professor David Bakibinga holds an LLB degree from the Makerere University, a diploma in legal practice from the Law Development Center, Kampala, Uganda, a master's in business law from the Council for National Academic Awards, London, and a PhD from Queen Mary University of London. He was admitted to the Ugandan bar in the year 1977. He has been a professor of commercial law, Makerere University, Uganda, since 1998, a fellow of the Uganda National Academy of Sciences, and then a fellow of the African Academy of Sciences since 2014, and a fellow of the World Academic Sciences since 2016. He has taught and supervised graduate students in the areas of corporate governance, capital markets, and intellectual property law, among others. Professor Bakibinga is also an author of numerous books and scholarly articles, including Law of Torts, Law of Partnerships, the Commercial Law, among other books and scholarly articles. So Professor is a former Dean of Faculty of Law at the Makerere University. He's also a former Director, School of Graduate Studies, and a Deputy Vice Chancellor, the Finance and Administration, Makerere University. He's also formerly a Secretary General of the Uganda National Academy of Sciences. He's currently a member of the Presidential Awards Committee. So Professor hasn't joined us yet, and he'll be joining us as we proceed with the presentations. And so he'll be able to say his hello and meet all of you. So without further ado, as we have noted, the topic that we are considering this afternoon is emerging trends affecting patents, trademark, copyright, and trade secret holders. And so we'll start with our first presentation of this afternoon. And this first presentation will come from Mr. Mkama Kalebu. So Mr. Mkama Kalebu, welcome, and over to you.
Thank you, Josephine. Thank you very much for your wonderful and well introduction. Thank you, viewers and listeners, for joining us in this wonderful session. I think we are going to learn a lot in the issue of IP and especially in the digital eras. So I hope we are going to have a wonderful session, and I welcome you very much. And as introduced by Josephine, we will be speaking on emerging trend affecting IP rights in East Africa, and this will be in trademarks, copyright, trademark, and the trade secretary orders. And in my part, I will be speaking on part of Tanzania, and I will be dealing much on research development from IP litigations as well as law and the rules amendment. As introduced by Josephine, my name is Mkama Magoti Kalebu, and I am a managing partner at End & Co Advocates. Without much wasting time, let me start my presentation and by introducing Tanzania. When you refer Tanzania or when you speak about Tanzania, you mean the two parts. You mean mainland Tanzania and Zanzibar. And basically, in mainland Tanzania and Zanzibar has its own system and the legal for protection of intellectual property. And the reason for this is the Constitution of the United Republic of Tanzania. It lists 22 matters of union matter. And intellectual property is not among the 22 union matters. So that is why we have different law and the system for protecting intellectual property in Tanzania and Zanzibar. And as an IP lawyers in both mainland Tanzania and Zanzibar, I will try to explain the major development in both Tanzania and Zanzibar. So by start, I would like to see the specific challenge those patent, trademark, and copyright face in protecting their intellectual property in artificial intelligence era. Now, the aim of intellectual property is to give exclusive right to the right to the owner of intellectual property. This is a major or the main essential of intellectual property. Now, the law and the regulation that protect this intellectual property, it is there to make sure that the owner of intellectual property enjoy this exclusive right given by law. Now, in the growth of technology, particularly the use of artificial intelligence and the blockchain, have direct impact on the exclusive right to use intellectual property granted or given by the law. Now, let us start by at least appreciating the meaning of artificial intelligence. Now, artificial intelligence, this refers to the computer system which are capable of performing complex tasks that historically this will only be performed by human being. And this computer capable performing things is this computer system are able to reason, are able to make a decision, negotiate, and come up with a solution. And in the current era, we can experience artificial intelligence like ChatGPT, whereby uses the large language model to generate text in response to text in a question or comment positive to it. Or the other example of artificial intelligence is a Google translation or Google Translate, which use deep learning algorithm to translate text from one language to another. Now, Now, let us now see having regard the impact of artificial intelligence in copyright. Now, this artificial intelligence in copyright, you can see artificial intelligence in copyright, whereby this artificial intelligence generates music, it creates an art, and even write script. Now, under the laws of Tanzania, under Section 5, Sub 1 of the Copyright and Enabling Right Act, the Act of 2010 provide for the protection of authors of original literary and artistic work. Now, if we go under section, sorry, if you go under section 4 of the act, of the same act, I mean the Copyright and Enabling Right Act, it emphasizes or it provides clear that only human authors are protected. This means that in Tanzania, there is no provision for protecting computer-generated work. So any copyright work generated by artificial intelligence are not protected under the laws of Tanzania. Now, with artificial intelligence, it is difficult to choose the author among artificial intelligence, the programmer, the user, or the entity that own artificial intelligence. Now, it is very difficult to choose or to determine who is the owner of the copyright work created. Now, the other challenge which face artificial intelligence copyright order is, while artificial intelligence produces an equal output, these are often based on pattern lineage from existing human-made content. That is to say, in artificial intelligence, the artificial intelligence, they don't create new things, rather than they use the available materials and the information in the network system or in digital manner, and they come up with another things. So it is like they are copying existing copyright. So that is another issue which face copyright order once when it comes to the issue of artificial intelligence. Then the use of tools in context analysis, such as probability detection or data mining, bring up the issue of unfair use and derivative works. This is another issue facing this copyright order once it comes to the issue of artificial intelligence. Now, this artificial intelligence also brings the issue of cross-territorial infringement on social media. You can find that you have copyright protected in, let's say, Kenya, but you find that one using maybe digital or internet infringe your right while here in Tanzania. So now, how these artificial intelligence are used in business. According to Forbes, Advisor Forbes 2024, business are using artificial intelligence tools in the following way. You can find 56% are using artificial intelligence to improve perfect business operation. 51% are turning to artificial intelligence to help with cyber security and fraud management. 75% arms artificial intelligence tools in the form of digital personal assistance. So you can find all these different modality or means on how this business use artificial intelligence. So by considering this example, you can see that it is now difficult under the current era, one, to avoid the use of artificial intelligence. So it is everywhere, every corner of business, being it goods or services. Now, in the trademark, this artificial intelligence has also some impact. Now, as you might know, the main function of trademark is to enable a consumer to differentiate the goods or services from one proprietor to the other proprietor. Now, under the development of this artificial intelligence, now you see that artificial intelligence are now able are now able to shop online and bring item delivered at your home. Let's say maybe today you can sit at your home, then you go online by using this artificial intelligence and they order something from the market. And this artificial intelligence can bring the goods at your home. So instead of consumer going direct to the market, and they have some choice on their own product, artificial intelligence are doing the same. Now you can find that maybe this artificial intelligence come up with a fake product or choose you a fake service provider. Now it is difficult for you to get involved directly to choose the specific product you need. And once it comes the issue of enforcement, now it is very difficult. So it has direct impact once it comes to the issue of trademark, especially on the consumer choice. Now, on the issue of patents, the patent system are intended to encourage and reward innovation. Now, these inventors disclose the invention to the world in return to monopoly of certain duration. Artificial intelligence system or machine cannot be an inventor under the Patent Registration Act of Tanzania. So can maybe an artificial intelligence can come up with an invention, but under the Tanzanian law, this invention developed or invented by artificial intelligence are not subject for protection. Only invention generated or created by human being are capable to be protected here in Tanzania. Now, let us see in our jurisdiction, I mean here in Tanzania, if we have any case opened which touch on the issue of use of artificial intelligence. In Tanzania, there is no case which has been opened on the issue of artificial intelligence. So the Court of Tanzania or the Judiciary of Tanzania has adopted the use of artificial intelligence in conducting court activities. And these are aiming of improving efficiency. And the Court of Tanzania, we can only find cases in Tanzania which emphasize on the protection of original artistic work that is delivered from the human work. And the good example is a recent case of Tanzania China Friendship Textile Company Limited vis-a-vis the Media Textile Mill Tanzania Limited, case number 106 of 2020, High Court of Tanzania, Dar es Salaam. In this case, the court, while citing the case of RSA Limited vis-a-vis Aspo Automate Limited, it held that for work to be protected by copyright under Section 5 of the Copyright and Labeling Right of Tanzania, plaintiff has to prove that the work is original and it belongs to him. That means it has to be original in real sense, and the plaintiff has to be the creator of the real sense. Now the issue is, having seen the current use of artificial intelligence, that you cannot do away with artificial intelligence. Now the issue is, are the laws in Tanzania sufficient to protect patent, trademark, copyright, trade secret order from infringement risk caused by emerging artificial intelligence trend in the line of fair use? Then in Tanzania, we have different laws which protect intellectual property right. For instance, we have the Copyright Enabling Right Act, CAP 218, revised edition to 2010. This law provides for the protection of copyright and related rights in literary, artistic work, and the folklore, and for the related right. Also, we have the Trade and Service Mark Act of 1986, which provided for the registration of protection of trade and service marks. Also, we have this Patent Registration Act, which makes provision for promotion of invention and innovation and the facilitative or acquisition of technology and the fair term through grant of regulation and the patent, as well as utility certificate and innovation activities. While in Zanzibar, we have the Industrial Property Act of 2008, and this is a law which provides for the protection of all industrial property rights. I mean the trademark, the patents, industrial design, utility model, and the utility model. Now, we have also this law which provides for criminalize any actions which any use of internet or digital manner in infringing copyright order. For instance, we have this the Cybercrime Act number 14 of 2016. This act makes for provision for criminalizing offense relating to computer, system, and information communication technology. It also provides for investigation, collection, and the use of electronic evidence and the format related therein. If we go under Section 3 of this law, the Cybercrime Act, it divides intellectual property to mean right accrued or related to copyright, patent, trademark, and other related matters. Section 24 of the Act criminalize any person who use a computer system to infringe digital property right protected under any law for both commercial and non-commercial users. And for non-commercial users, a fine is not less than 5 million, or imprisonment, or for both imprisonment and 3 years, and both fine and 3 years imprisonment. And for commercial use, if you find a fine is not less than 20 million, or imprisonment, or for term not less than 5 years or both. Also, the victim, I mean the copyright holder or the intellectual property holder who can apply to the court for compensations. Now, strictly speaking, instead of having all this law, but they are not
Josephine?
Yes. Thank you so much for that presentation. So we'll move to the second session, the second presentation of the day, and this will come from Mr. Just a minute. Yes, so thank you so much for that presentation. We are now ready to move to the second presentation of the day. As earlier on discussed, the topic that we are considering is the emerging trends affecting patents, trademark, copyrights, and trade secret holders. So the next presenter who is going to make a presentation in terms of the experience in Rwanda is Mr. Pius Ntanzinda. So welcome, and over to you, Mr. Pius.
Yes, thank you so much, Josephine. I think we have internet over East Africa, so if something is not, if I'm not audible enough or something is wrong, you communicate. Greetings everyone. Thank you for joining this session. The previous presenter said, we are covering the topic. Sorry, a moment. If you allow me to share my screen. Josephine, I'll be relying on you to tell me if everything is in order on my side.
Okay, so we can hear you in terms of your voice. So we are looking forward to see the presentation.
The presentation is on correctly?
Not yet, not yet.
Okay. And try again.
Okay, yeah, you can try again.
How about now?
Yes, now we can see it. Thank you.
Yeah, thank you so much. So the trends affecting, I'm not going to say, I'm going to say generally IP rights holders in Rwanda and the recent developments. I think when we talk about emerging trends, normally we are looking at what has not been traditional, what has not been done before that is currently happening. And briefly, this is just like a note on my side to know what I talk about, but this is not mainly the notes for you to take. But I'll talk about the importance of intellectual property for innovation and entrepreneurship, and then IP legal framework in Rwanda, then the emerging trends, and the AI policy in Rwanda, and then the challenges and benefits. So we understand that to have proper inventions or innovations and other developments in the country, we need a proper regulation and we need a proper legal framework. This helps in innovation because the innovators or inventors are comfortable that one, what they're producing is rightly protected, and they can be guaranteed of protection in case there's an infringement. So, and this leads to the legal framework that we currently have in Rwanda. The current framework we have is the intellectual property law, which is law number 31, 2009 of 26 October 2009. This is the general law that governs intellectual property in Rwanda. It covers mostly two parts: the industrial property and the copyrights and related rights. Now, it's being revised, and we have a new bill that has been pending for some time now, but following a new intellectual property policy of 2018. In the case of Rwanda, the ministry or the responsible ministry sets up a policy, and then in our case, which is the Ministry of Trade and Industry, and then this is followed by a regulation or by a law. So we have a new policy that, as you know, in terms of regulation, you need to keep up with the latest developments. So the new policy is intended mostly for aligning the IP policies and practices and strategies with the country's vision and targets, focusing on advancing scientific and technological skills, supporting economic exploitation of innovative projects by creators, inventors, and innovators. So the framework is aimed at making sure that we can get the best out of the inventions that are created, and the inventors themselves can get proper protection. I mean, Josephine, the light is quite affecting in my background. If give me a moment, oh, okay. So as I was saying, the laws or the policy aim at giving proper protection to innovators, making sure that what they will create will be protected. Now, in the case of new technologies or emerging trends that come up, the laws or the policies need to keep up with the latest developments. And this is why you see that, I don't know in the case of other countries, but in Rwanda, the laws keep changing from now and then. So if I'm to talk about the emerging trends and mostly what is the topic of what we're discussing mostly, and is AI. The way AI is affecting the way things are done in the world, and specifically in Rwanda. How do we regulate AI and its use in Rwanda? The current framework, the framework currently concerning IP, the law that I talked about, does not provide specifically for use of AI. But I think even my colleague from Tanzania said so. What is protected is the creation of human mind. So basically, there's need for a human mind behind any creation for something to be protected. And so that's the regulation that we're currently basing on. That's even though there's use of AI in all the inventions or most of the inventions that are created in Rwanda, but you cannot protect something that has been totally produced by a computer. So our hope, sorry, Josephine? Okay. So our hope is that with these emerging technologies, we can find the regulation that properly matches their use and control the way they are used and give protection to the creators. So, but what the AI is used for in Rwanda in IP, for example, you can find products that are AI-based that are used, for example, in conducting searches, IP searches, assessing patentability and predicting the outcomes of applications, IP applications. So it's used, AI helps as a facilitator, but not in itself as a product that can be protected. So the recent development that we've had is the National Artificial Intelligence Policy. It's the framework from the Ministry of ICT and Rwanda Utilities and Regulatory Board. They came up with this policy, and it's basically a strategic roadmap to harness the benefits of AI and also mitigate the risks that can be caused or that are associated with AI while bringing up sustainable and inclusive growth. So we hope that that framework or that policy will guide the nation in keeping up with the latest development in that area. So we have many players in that sector. We've seen many organizations getting involved, making sure that creators are protected and what they are creating does not have negative effects on human population. I think you'll agree with me that if we let computers do what they want without limitation, it would be hard to control, and we wouldn't be easy to control or to monitor what they do. And this is why I'm saying there's need for human involvement or human guidance on what the computers can do. So with that framework, we hope that the creators will create things that are not affecting the rights of other creators, but they are not also creating things that can turn out to be criminal. Of course, the current IP law that we have gives protection to authors and creators and inventors. Yeah, it protects against forgery, it protects against infringement, both criminal sanctions and civil sanctions. And this altogether goes to protect their creations. However, the challenges that we're having is that any changes, as you've seen, the law we have is of 2009, and we are now in 2024. In between, there's a lot that has changed that needs to be regulated. So the laws do not normally keep up with the speed at which human innovation goes with. So there's a total lack of speed in keeping up with these new technologies. And sometimes you find that they'll be regulated not in a proper way. For example, someone will create something new that is not regulated, and you'll have an officer or a certain authority saying that such a thing should not be protected. When we talk about blockchain technology, when we talk about NFTs, so you find that things are new and people are not aware So people become an obstacle because there's no proper regulation concerning such an invention or an innovation. So, but we think, or my thought is that if AI is used properly, it can be useful in addressing the challenges that are faced by creators and copyright holders, including protection in the content they do, whether it's online or whether it's digital or intangible. And it also helps in the distribution of such content. If I go back to what we have currently, the emerging trends, we have solutions. For example, in the health industry or in ICT that are backed by AI that are helpful. For example, if we talk about machine learning, you'll find that you have softwares that help people for example, using previous data to guide on the future. For example, if someone might come up with an app that gives timelines on when you should do, for example, your motor vehicle inspection in Rwanda, or whether you vaccinated your kid today, and you've done it over time, how long will it take you to do it again? If you have an insurance policy, you have apps that help you to tell you when the next renewal is going to happen. That's just AI collecting the previous data and telling you it's happening at this time of the year. And of course, this goes hand in hand with the Earth data, where you have, for example, solutions that tell you there's going to be traffic around this side of the city. Like currently, we're hosting Africa CEO Summit, and most of the roads are closed. So there's an app that can tell you, please don't use this road. There's going to be a lot of traffic. There are also solutions that tell you about the weather changes, whether it's going to rain or not. So all those creations are there and they're backed by AI. So the important question is, how do we regulate that, or how do we help someone who has come up with something like that, that it's not being infringed on? And I don't want to go into the details of complex AI. As I think it's my colleague who talked about Chat GPT and other things, like we've seen on social media. You have a song is reproduced in a different context, keeping the words, for example, keeping the same rhythm, but a different, produced by someone else. How do we protect that? So all in all, we don't have such a specific regulation. I think it's left to the interpretation of the enforcement agencies and the lawyers, of course. How do you explain your case? How do you say your invention has been, or your protected right has been infringed on, to argue it out? As I conclude, the legal framework in Rwanda is evolving to, reflecting what is happening globally. And the hope is that with the proposed amendments to the IP law, we can have something that is specific to the emerging technologies. I think it's the EU that has worked on something related to AI, and we hope even in this side of the world, we can keep up the pace with the new trends. I'll end here and let us have a discussion specifically on what is happening in Rwanda. Thank you so much.
Thank you so much, Mr. Ntanzinda, for that very elaborate submission and for sharing with us your experience in Rwanda. It's quite interesting to learn the different frameworks. And now, ladies and gentlemen, for our next panelist, Miss Eileen Aluso, to share with us the emerging trends in Kenya. Miss Aluso, you're welcome to present.
Hello, everyone. Okay.
Yes, welcome, Eileen. Eileen, we had already done the introductions in terms of profiles. So
That's
just
fine.
go ahead. Yeah, go ahead, share your screen and the slide. Then after your presentation, we'll have a Q&A.
Okay. So there's no slide on my end. I will submit them for them to be sent to you guys who are in attendance. I had been asked to talk about the emerging trends and challenges in enforcement of intellectual property in Kenya. And I'll focus my presentation mainly on the current technological advancements in Kenya and worldwide, and more specifically on artificial intelligence and blockchain technology, and also the challenges related to counterfeiting products and what Kenya is doing about that. So the agencies, stroke government bodies that are in charge of implementing and enforcing intellectual property rights in Kenya are the Kenya Industrial Property Rights Institute, the KECOBO, Kenya Copyright Board. We have the the Kenya National Innovation Agency and the National Commission for Science and Technology and Innovation. So these bodies work sometimes independently and sometimes together, depending on the different issues that are presented before them. The current laws in Kenya that touch on intellectual property is the Industrial Property Act, and most recently, the anti-counterfeit regulations of 2022, which will be part of my presentation. We had at some point a bill that was looking to amend the intellectual laws in Kenya, the intellectual property laws in Kenya, that is the Industrial Property Act. However, the conversation has somewhat stalled because we had the conversations about 2 years back, and the changes that we were discussing have not yet been implemented. So is that now we are still using the Industrial Property Act without any amendments. So I'll go to the challenges of enforcing IP rights in Kenya, and I'll deal with them wholesomely. That is trademarks, patents, PT patents, and copyrights. We find that for issues to do with patents and trademarks, we have a lot of counterfeit products in the market. You find that some people basically reproduce products that belong to other manufacturers and resell them at a cheaper price. So the anti-counterfeit regulations of 2022 make it compulsory for importers to record their IP rights. It's called recordation of intellectual property rights. This is done at the Anti-Counterfeit Authority of Kenya. For one to practice there, you need to be, a registered agent at the authority. So what happens basically is you first have to register your intellectual property rights in the normal way. That is through KIPI if you're doing it locally, ARIPO if you're focusing on the African scope only. And if you want to go through WIPO, it has to be registered first there. And then after that, now you go and do it at the ACA, that is the Anti-Counterfeit Authority. And once that is done, you identify your agent, who will then be the person who is like the contact person at the point of entry in the border points. So say, for example, if you're importing cups and you're manufacturing cups and you're importing them into Kenya for purposes of distribution through your distributors, your agent at the Anti-Counterfeit Authority has to be in touch with your distributors. These are the legally recognized distributors. They also have to be disclosed to the Anti-Counterfeit Authority, and these have to be inspected before they come in. So if they are legitimate products, they will come into the market. If they are not legitimate, then they will be denied entry into the country. Now, important to note, this is still a new legislation, is still being implemented. So it's a step-by-step process. For those products that are already in the market, the anti-counterfeit products already in the market, you find that the owners of those products who have their IP rights registered conduct an exercise called market survey, where they engage their IP representatives at the ACA to conduct the market surveys, and the scope of work is dependent on what exactly they need to be identified that is in the market. So say, for example, you could have what now? Spare parts of your car, whatever car you use. You could identify the brake pads, the windshields and whatever. And then they provide that training and tell you this is what we manufacture, this is how to identify the real and the fake. And then the scope of the extent of the counterfeit products is identified. And then we liaise with the Anti-Counterfeit Authority for purposes of recalling these counterfeit products from the market. And then depends now if the manufacturer prefers to get into agreements with the people supplying these products, or if they want to prosecute them, and then the legal process is taken up from there. So that is one of the main challenges that I have personally identified in the Kenyan market: counterfeit goods, both in the form of patents and trademarked goods and products. In terms of copyright, you find that we are currently in the age of e-marketing, e-commerce. We also have a lot of content creation and digital media. So you find that there's a lot of cross-pollination, for lack of a better word. You find that there are these social media channels and platforms like TikTok, Instagram, Twitter, and you find that there's a lot of copying of each other's content. So that is largely under copyright, and you find that it's so difficult to protect your copyright under in these platforms. So that's a challenge that is ongoing, and it needs collaborative efforts to curb the infringement of the owners and also create awareness, because you find that most of the people who use these platforms, especially the TikTok generation, are largely unaware of the importance of protecting their IP rights, importance of protecting their content that they post out there. And so creating awareness is important, and also making it easier for them to, once they have the information, it should also be easy for them to protect their IP rights. So for example, at Kekobo, it is such a simple process. You just go online, log into the portal, register your account, and register your copyright or whatever you want to register. They will guide you. If there are any issues, they get back to you. The process at Anti-Counterfeit Authority is also quite easy to use. The same as a portal, you register there and you can record your intellectual property rights. KIPI is still largely analog. It's not yet digitized, but we are hopeful that soon it will be made digitized completely. So the challenges that we have in artificial intelligence vis-a-vis intellectual property rights, you find that it's difficult to determine the inventorship and ownership of AI-generated inventions. And then we also have making legal ownership of these AI inventions. Who is the owner of this invention that is AI generated? So you find that the proposals that are being made to address these kind of issues are legislative amendments, so that the current existing laws address issues of recognizing artificial intelligence systems as inventors, and then designating their human developers as the owners of those intellectual property rights. Because you find that these AI-generated inventions are largely coming from a point of algorithms and all that. So it's a bit complicated in terms of attributing the true ownership of that invention. So we can do a sort of like separation the inventor being the AI and the owner being the developer, the human aspect of it. Then we also need to establish a clear criteria for assessing the creativity of AI generated works. In my opinion, this takes us back to the developers, the humans behind it, because you find that at the end of the day, all these things are created by human beings. So you cannot remove the human beings from this whole conversation. So the creativity aspect of it can be attributed to the human beings behind the AI generated inventions. So then we'll have issues of novelty and patents and etc. Then we can have a system of implementing financial rewards and incentives for the AI developers, that is the human beings. Maybe come up with something like royalties, like the way it is in copyrights. So then if we can encourage that, then people will be more motivated to come up with more artificial intelligence development and generation of this kind of inventions. We also have cross-border disputes, which are becoming more and more common, and jurisdictional challenges. And this is largely because of how the world is now becoming one small community thanks to technology. And we have things like TRIPS, the international agreements that govern intellectual property rights. We also have this one in Ghana, I have forgotten, that governs trade in Africa. And the whole idea is to reduce the tax implication and cost of doing business in Africa. I'll tell you the name when I remember it. So these cross-border disputes make it a challenge. So you find that at the end of the day, the intellectual property rights are faced with expensive processes in resolving legal issues. And it is encouraged to try and have more collaborative approaches to resolving disputes as opposed to litigation, which is a bit difficult. Arbitration is also costly. It's ideal for well-established organizations, but those who are just starting out find it to be complicated. So we can have licensing agreements and stuff in those lines to try and find middle grounds in terms of doing business, because IP is also at the center of doing business. You cannot separate the two. And it is always encouraged to continue doing business even as you try and resolve intellectual property rights disputes. So we also have the problem of easy replication and distribution. That's largely because of the e-commerce platforms that we have, the Amazons and all that. It is so easy for me to just go online and see something I like and reproduce it from here and sell it without attributing ownership to the original creator. So also piracy and unauthorized use of digital assets that can also apply to AI-generated artworks. Copyright comes into play. Then we have biotechnology and intellectual property, where you find that we have gene editing and creation of new medicines. What are the ethical implications in this kind of situation? Who is to attribute who is to own the IP-related rights? And if there is an owner, is it, morally and ethically right to patent these kind of things and make money out of it? So those are conversations that are ongoing. We need a balance between incentivizing innovation and safeguarding the broader public interest, because you find science innovations are largely to provide solutions to existing problems or emerging problems in society. So on the one hand, we have to consider the public interest, where you have to encourage innovations to take care of societal problems. On the other hand, you also have to encourage these people who are coming up with these inventions so that they keep inventing and keep coming up with these new solutions to the problems in the society. So that's a delicate balance that we need to make. Then we have, under AI-generated artworks, the question on copyright ownership. What is the legal framework that governs these copyright issues under AI-generated artworks? Then what is the role of human creativity and intervention in AI-generated artworks? So those are ongoing conversations which are not currently defined under any existing laws, but we hope that once we do our amendments of the laws, they will be captured therein. So we also have blockchain. Blockchain, in my opinion, is creating a good precedent in terms of establishing the ownership of intellectual property rights in this new age of AI and IP. And the reason is because blockchain creates a record of transactions in whatever that is done. So it is easy to know who came up with this and how like a paper trail, like the way you have the login detail in platforms like National Transport and Safety Authority in Kenya. So blockchain has that kind of thing, and it's easy to then identify the source and how it processed until where it is now. So in summary, that is it. I will just give one example of a case that is was recently decided and touches on these conversations we are having. We have in Taiwan, where a car manufacturer decided to copy, for lack of a better word, another car manufacturer's smart technology. And the car manufacturer that originally came up with that sued for that, and they were it was found that indeed the other smaller company had infringed on intellectual property rights. And instead of them being penalized, they agreed to come together and enter into a licensing agreement so that the small manufacturer can then use the other party's smart technology in manufacturing their cars, and then they can come together and share the profits. So that is the end of my presentation. I am open to receiving queries from the attendees. Thank you. Josephine?
Yes, so thank you for that presentation.
Okay.
Thank you for that presentation. So in our list of panelists, we were supposed to also have a professor, but then sadly, he is unable to join us today. So that means we'll just proceed and pick up questions that we have.
Maybe Josephine, I get lost due to my network. Maybe I can proceed with my presentation where I ended, so that I finish, then we go to questions. If allowed, please.
Okay, then you can proceed.
Thank you, thank you. Thank you, dear viewers, and many apologies for what happened. It was beyond my control. And allow me to proceed where I ended. And I ended where I was talking on the issue of copyright and whether the available law meet the current condition of artificial intelligence. Now, allow me to go to the next slide, and I will take you through and see if there is any notable change made in the intellectual property law or system in Tanzania. Of course, there has been some amendment in intellectual property laws in Tanzania. And the first amendment or change, you can express it in the Trade and Service Mark Act. And through Written Law Miscellaneous Amendment number 3, 2021, introduced the new amendment to the Trade and Electronic Seal, the signature, and the electronic documents. And they also introduced the online filing system of trademark and the patent. So it is through this law now all application and application for the registration of trademark and patent are done via online. There is no need of submitting papers. Only what you need to do is have your IP rights filed via online. And another amendment is the enactment of the Personal Data Protection Act number 11 of 2022. Now, this law is all about the protection of personal information. As you might know, when you are filing intellectual property, let's say trademark, you have to provide your personal information like names, your phone number, email, and the law. There is no section or phrase which protect this disclosed information. Now, under this Personal Data Protection Act, it comes to cure this gap. Now, with the enactment of personal data, no personal data relating to patent, copyright, trademark can now be used by the data controller, the collector, or data processor for any commercial purpose without the prior consent of the data subject. Now, no, the registrar or any other officer in the office of the registrar can use this information, the provided information for person or any purpose. And now, if that happens, now the owner of patent or trademark or any intellectual property can now go to the court and have issue or have a case on the infringement of or the use of personal data without consent. And the other issue is Finance Act 2023. Now, this Finance Act bring is the introduction of Copyright Office of Tanzania, or the office. Before this change, it was known as the COSOTA, Copyright Society of Tanzania. Now is the Copyright Office of Tanzania. The other change which this act brings is the introduction of collective management organization. And the other issue which this act brought is the imposition of copyright levy. The amendment imposed on copyright levy at a rate of 1.5% to be charged on the value of radio or TV set, enabling recording, analog audio recorder, video recorder, CD or DVD copies, digital jukebox, and MP3 players. So all this now are subject to copyright levy at the rate of 1.5%. Another change or another major change which brought by Finance Act is the imposition of copyright to include to build mini disc, compact disc, digital versatile, CD memory between the word digital jacket and the MP3. Now, these are the major changes which have been made in the copyright by the Finance Act 2023. Now, we have also experienced a major development as far as well-known mark and the business name for signage. Now, in the case of DC Decos, SCA, and the DC Decos Tanzania Limited, commercial case number 155 of 2018. Now, this case come up with a strong protection of well-known mark and a well-known business name. Now, this case emphasizes on the need of protecting well-known mark in Tanzania. It is the court decision that Any mark which is well known in Tanzania should not be used by any person so long as without considering that they are not protected here in Tanzania. So in our laws, the Trademark and Service Act provides the protect the well-known mark, but it is this case which come up to cement on the issue of protecting a well-known mark as well-known business mark or a business name which is well known all over in the world and also well known in Tanzania. So don't worry if anyone now infringe your trademark or your well-known business name, if it is all are not registered, you can file a case and get redress and get your right under Tanzanian trademark, and by using this case, get the cause. And now it is also important to see if those highlighted change will they give redress to the right order or to the intellectual property right order in face of artificial intelligence. Now, as said in copyright matters, the introduction of collective management organization. Now, before this collective management organization, the responsibility to manage economic right in the field of copyright and enabling right was to the owner of house or owner of artistic work. And this was done through different ways. One of those ways being contract. So it was only through this mechanism where the owner of copyright will have able to protect his or a right under copyright. Now with this collective management, now we see that copyright owner can collaborate with collective management in protecting his or her copyright. Now, this collective management is indivisible because they would be unable to control themselves the mass use that take place, taking into consideration that IP or copyright is in a digital age. It is not possible for individual person to control, but by using this collective management, it is now able for this person to get his right protected rather than protecting by personal means of protection. Now, as those changes done able to balance the interest between the right, the intellectual property holder while promoting innovation? Is it true that those amendments, as highlighted above, sufficient to protect or to balance the interest between the interest of IP holder and innovation, the current innovation? Now, as you might know, the role of IP in a developing country cannot succeed their core economic function if rights are disregarded or are too expensive to enforcement. For instance, if you find that you have a system of protecting intellectual property, and you have the law which provide this protection of intellectual property. But if your system is too expensive, the owner of this intellectual property will not be able to protect his or her intellectual property. So it is, this system must be simple and it must be easily accessible to make the protection more easier for this intellectual property. So I've seen with the coming in force of online protection of trademark by the Tanzanian Trademark Act, now it makes this protection system simple and easier. So it allows and it is affordable for the right owner of intellectual property to protect his or right. Although there is no recent amendment in the patent law, but in other areas such as trademarks and copyright, the changes made are going to reduce the burden, especially on the protection of intellectual property. And the issue of how this how this policymaker and the legal expert navigate the fine line protecting IP rights and promoting fair competition in the digital age, especially considering the rapid pace of technology change. Now there is this issue of territoriality principle. You may know, intellectual property is an issue of territoriality. That means intellectual property granted in one country will not extend to the other country. Now, but the internet is free. Once, for instance, you are in Kenya, you can access information available in Tanzania via online or internet. Now, you can know also intellectual property, maybe a trademark used in Tanzania. Now, territoriality restriction is not a barrier to IP infringement on social media. Now you have your music and you own your copyright in Tanzania, but someone in Kenya can use the same music. And if it comes to the issue of territoriality, it is very difficult now for you to claim your right. Now the issue is, do we need digital trademark protection or copyright trademark protection or patent protection parallel to the traditional available means of intellectual property protection? Do we need that one so that we have the same the similar trademark or patent or copyright protection system? And if this is okay, then we can see. If this is not okay, also we can see on the best way of getting away with this issue relating to internet infringement of intellectual property right. Then we have this issue of maybe sound mark or smell or taste mark. Now, if you come to the law of Tanzania, they not recognize sound as a trademark, or they don't recognize smell as a trademark, or also they don't recognize taste as a trademark. According to Section 2 of the Trade and Service Mark, they define a trademark as means any visible sign used or proposed to be used upon in connection with or in relation to the goods or service for the purpose of distinguishing in the course of a trade or service or business the goods or service of a person from those of another. So this law, it only recognizes the visible sign. We see it only recognizes the visible sign. It does not recognize the sound. Sound are not visible. Smell are not visible. Or taste are not visible. Now, don't we see that it is now a right time to do away with this definition to include so that we can cover the issue of smell or the issue of sound as a trademark, bearing in mind that we have, for instance, in other jurisdiction, which recognize sound or smell or taste as a trademark. As you can see that in the current commercial or global world, advertisement are done by using sound or by using also smell can function as a trademark. So it is now highly recommendable here in Tanzania to have amendment of this old law which recognizes only visible sign as a trademark. Having said so, I thank you, and Joseph, thank you. You have your time. Thank you.
Okay. So thank you so much for that elaborate presentation. Indeed, the listeners who've tuned in have had some great insights when it comes to emerging technology and how it affects the IP rights holders. So at this point, I think it's the right time to now delve into the questions. So I'll just request for the participants who are present, if you have any questions, please post them on the Q&A so that we can pick them up and engage our panelists. So to start us off, just to the three of you, and then we can respond in the order of, we'll start with Mkama, then Eileen, and then Mr. Pierce. In terms of the current laws that you have in your different jurisdictions, so you have Rwanda, Uganda, and Kenya, could we say that the current laws are sufficient in terms of protecting the creatives and the IP rights holders when it comes to these emerging technology? We can start with Gabriel. Sorry, not Gabriel. Mr. Mkama.
I said the available system and the law which protect intellectual property, they are not adequate enough to cover the issue of infringement caused by artificial intelligence. So in Tanzania, we have this law which criminalizes the issue of digital infringement of IP right, but they are not adequate enough to cover the issue of infringement. So they are not adequate enough. I have seen at least in Rwanda they have a police which cover the issue of artificial intelligence. The police, at least I think they have somewhere to start it. But here in Tanzania, don't have such a mechanism. I think it is the right time now to have at least such kind of modality. Thank you.
Okay, so we can go to Miss Eileen. From the Kenyan perspective, could we say that our laws are sufficient enough to, protect the IP rights holders when it comes to these emerging technologies? If not, what would you suggest? How do we go about it?
Thank you, Josephine. No, our laws are not sufficient to cover the emerging issues. They were sufficient for the old days, if I may use that term. But as I had stated during my presentation, we need to amend our laws to address these emerging issues. For example, I give example of AI, where we separate the issue of the invention and the owner, the developer being the human aspect of it. So my proposal would be we should be more proactive in amending our existing laws so that we capture these emerging issues. And also we should be on top of things in terms of what is happening in other jurisdictions, both within Africa and outside Africa, so that we can borrow and see what we can implement on our end. However, I also would like to applaud my country people. We have the anti-counterfeit regulations of 2022, a very recent legislation, which is working towards curbing counterfeiting, which is a live issue under enforcement of intellectual property rights. Thank you.
Okay, thank you so much for that. Then we move to you, Mr. Ntazinda.
Oh, yes. Well, it's the same here. I wouldn't say the laws are sufficient. But remember, guys, we're discussing a topic that is quite complex. Like you said, it's emerging technology trends. So it's always hard to keep up. And given the legislative processes that we have in place, where a law has to go, in our case, through the legal reform to becoming a bill in the parliament, the process or how long it takes is quite challenging that you keep up. Like I said, our law is currently one of 2009. I mean, it could be actually new compared to other countries. And now we have an amendment coming up. So it takes quite some time. But what I feel like should be done is to have some authorities empowered to come up with regulations instead of what you'd call a proper, in our case, organic laws and such more important laws. So we have the Ministry of ICT. It's easy for the minister and the relevant members to come up with regulation relating to certain matters. So it's much easier. And I think in Rwanda it's been done. Like I told you, we have a policy, we have a Center for Fourth Industrial Revolution. So I think we try to keep up, but then it's hard keeping up with the technology. Yeah, and again, the question is, how can you regulate internet? How can you, it's hard. Sometimes you don't even want to do that because you're going to affect innovation. You don't want to super regulate, if I'd say. Yeah, thank you.
Okay, thank you so much for that. So moving on, I think the other question that we need to also consider is, now that we've considered East Africa, unfortunately, Professor wasn't present today to give us the perspective from Uganda, but then I would appreciate to also hear a comment from the three of you in terms of, are there any potential areas of collaboration in terms of strengthening the laws that we have in the different jurisdictions so as to ensure that the IP holders are also protected? So do you have any comments on that particular question? How can East African countries collaborate in terms of strengthening the laws that are there in place or the policies in place so as to protect the IP right holders from the effects of the emerging trends when it comes to technology? So we can start again with you, Mr. Mkama.
Yes, to me, I think that is very possible, taking the current trend of the East African community and the laws we have under the East African community. And at least we can appreciate there are some provision under the East African community law which provide for the protection of intellectual property. So it is a matter of administrative bodies and judiciary bodies across the East African country to make use of those provisions and the available current national laws to enforce this intellectual property right. And also we can maybe share some, because East African we have this movement of East African trade markets also. So if we start area mechanism of protecting this IP rights, I think that one will be more helpful to this intellectual property right holders. Thank you.
Okay, Mr. Mkama. Sorry, Miss Eileen Alusov.
For me, to add on to what Mr. Mkama has said, I would encourage member states to collaborate and work with ARIPO and also the AFCTA. More member states should also become signatories to the existing legal instruments that touch on IP through ARIPO, because ARIPO, Africa Regional Intellectual Property Organization, is the body that governs IP in Africa, and it does this in collaboration with WIPO, with EU IPO. So they bring on board all these experiences from other jurisdictions outside Africa and try to implement them into the African context. So member states, through the government, respective government offices, can tap into that resource, send representatives and mandate them to constantly engage in terms of strengthening our existing laws, improving them, and also staying up to date on the developments across the continent. Thanks.
Okay, thank you. And lastly, to you, Mr. Ntanzinda.
Yes. I also feel like it's very possible. One, through the East African community, of course, where all of us are members. I mean, don't we have, we are collaborating when it comes to tax matters. I think because it generates revenue for the government. So I think more effort needs to be put in other aspects of integration as well. So we can collaborate on a regional level. As I think Eileen said, we have AFCTA IP protocol. I think that is coming up, and we have EU working together. So we can collaborate on regional level. There's proper legislative powers, but also we can collaborate on nation to nation, learning from each country. Do you look at their law? I mean, we like I said, we have a framework for AI. Is it the same in Kenya? Of course, they got it from somewhere else. Can we copy that? Can we learn from each other? We have data protection regulations. We have the same. So we are more connected than ever now. So I think we need to be learning from one another and imitate the good things from each side. Thank you.
Okay, thank you for that. So we move to the questions that are being posed by the participants. The first question is from Celius Bugingo, who is asking, I would like to know these according to the different jurisdictions. In Rwanda, intellectual property to be protected needs to be registered by its owner. But there are some properties, sometimes which may be protected, but not easy to be registered. How should these properties be protected in order to profit from its owner? So Mr. Bugingo also goes ahead to note that, to clarify the question, and he notes an example where sometimes you might have creatives or maybe the celebrities and musicians or any other person who can come up with a statement, and that statement might become popular. And so he's asking that companies might take in those statements and utilize them for purposes of marketing. So how do you go about protecting such statements? I think we've had these scenarios in Kenya, and I'm happy to hear that even in Rwanda, the same is happening, where politicians, musicians, yes, they'll come up with slogans or tags that might come maybe from some songs or just, out of some political statements, but then these become popularized. And so, of course, they will attract IP rights. So I would love to hear from you, Mr. Ntanzinda, since the person who's asking is asking about the question from a Rwandan perspective. What would you have to say about that question? Over to you.
Sorry. Let me read through again, because I don't think.
Okay, let me simplify.
I need to understand what he means that some properties could be.
To simplify it, he means intellectual property arising from statements that can be made from celebrities or even politicians. An example here in Kenya, we've had such scenarios so many times, so many times where a politician will be in a political gathering, he'll make a certain statement, and it is utilized all the time. And so Of course, from that statement, they can either decide to utilize the IP right in it in terms of protecting it through copyright or trademark so as to, benefit from the same. So since the same thing is happening in Rwanda, he's asking, according to Bugingo, he's not so clear in terms of, he's posing the question that sometimes it's quite difficult to protect this intellectual property, and he would like some guidance from your Rwandan perspective, and then now the others can come in to put in their perspectives from the other jurisdictions.
Yes, from the Rwandan perspective, of course, I wonder if, in terms of copyright, like I said, we have industrial property and copyrights and related rights. In terms of copyright, how do you call such a statement as a work, for example? In the definition, I think it would be hard. Maybe it would be hard to have it protected because you're going to say words that have been used, basically mere words. It's not a song, it's not something new, but maybe in form of a slogan, you could protect it. We've seen slogans everywhere being protected as trademarks. Live it, love it, many slogans. If you make a slogan and you think it's important, you can protect it, but um, it has to be protectable, if I'd say. Is it not descriptive? Is it not imitative? Is it so? I think it depends on case by case basis. What kind of slogan? Are you going to protect a whole sentence, or how long is it basically? But not for speeches of orators and presidents. Of course, you cannot imitate that. It's protected by law. You don't have to have it registered. Uh, no one, you can repeat it, but you have to quote. You don't basically make it your own. I can't just come up with a speech that was used by someone else and I make it my own. It's protected in its creation. I hope, and I invite my colleagues to assist on that as well.
Thank you so much for that response. So we can hear a comment from Ms. Eileen in terms of the Kenyan perspective. I hope you got the question.
Yes, I did. Basically, what I would say is that these kind of things are protected under the trademark regime in Kenya. The slogans are done under, brand names. And I'll give an example of this slogan, bazoo. It's a common word here in Kenya. To mean, I think, I'm not very sure, but it means like big man, because the person who came up with the slogan is a local presenter TV, was local. He moved to the CNN. And he used to use that phrase a lot during his presentations because of his target audience, and it was quite the hype. So Airtel Kenya decided to take the slogan stroke phrase and use it to market its certain bundle, internet bundle across the country. So this local presenter decided to sue for trademark infringement, and he won the case, and he was awarded Kenya shillings 5 million. So yes, it's possible to protect those kind of slogans in Kenya. Thank you.
Yes, so thank you so much, Eileen. Yes, and indeed, in Kenya, we've had such scenarios, and you can see that, for instance, the media personality who came up with that buzzword, he went to the Kenyan court, he filed his case. Actually, he had already trademarked that word bazoo, so he went to court and he was awarded the damages. So you can clearly see that these are things that are practical, and they're possible, so that whenever there are any IP rights arising, you can be able to register and obtain any damages for any infringement that takes place. So Mr. Bugingo, I hope we have satisfied your question in terms of the answer you've been given. So I'd like to call in okay, let me ask the other question that has been posed. There's Mr. Robert Kadaso Mageni who is asking, how is it possible for member states to form or enact a protocol or legislation for the joint protection of IP against artificial intelligence? So for this question, I would like to, let me see. I think we can have any of the panelists answer that without any order. Let me see, yeah, we can have, Eileen, you'd like to start? Yeah, you can just take it over.
Yes, also because I would like to leave in a few minutes. So if there won't be any more questions, but answer Mr. Robert, yes. How member states to form? Well, what I can think of right now, within the East African region, we can come together under the East African community and come up with a legislative framework that governs AI and IP. In the wider African scope, we can go under a RIPO, come up with a protocol and get but member states to sign up to it so that it can be binding on the respective states. Obviously, there has to be a lot of dialogue and meetings and etc. to decide on the content of the policy before it can be implemented. Thank you.
Okay, we can hear a perspective.
Yes.
Sorry. Yeah. We can hear your perspective. Yes, Mr. Mkama,
Yes.
go ahead.
Yes, thank you, Josephine. I think to me, that is very possible and it depends on political will. And we have good example in West Africa where they have one law which protect intellectual property for their own OIP member states. So it is very possible and it is a matter of political will. Thank you.
Okay. Mr. Ntazinda, do you have any comments on that particular question?
No, I concur with what Mukaman has just said. And yeah, I just wonder if maybe Robert's question wasn't about one country enacting a law that governs other countries. Maybe it's in the wording, but if it's on a regional level, I think what my colleagues have answered is okay. But one country cannot enact a law and then that can be adopted by everyone else, unless maybe they become the initiator.
Okay, so thank you so much for that. I think I can't see any further questions from the attendees. And so then we can now approach the closing session in terms of the topic that we have had today, which has been emerging trends affecting the IP right holders when it comes to technology. So perhaps we can now proceed towards your closing remarks. And I can give Eileen Aluso the first opportunity to present her parting shot when it comes to today's topic. Eileen, are you still present?
Yes, I am.
Great. So go ahead.
Well, thank you. I'll just say that there's a need to balance the need to protect intellectual property rights with the fostering innovation and ensuring access to information in this digital age. And then we also have to be alive to the ongoing struggle faced by authorities in the different jurisdictions, the IP rights holders and the relevant stakeholders. And they have to continue finding solutions to the ongoing issues and adapt to the digital landscape and address these issues, like, for example, online piracy, counterfeit goods, and the protection of IP rights in the age of rapid technological advances. Basically, this webinar has been very timely, and it underscores the importance of finding a delicate balance that promotes innovation while safeguarding creators' and innovators' rights and the public interest at large. So thank you for hosting us and for the attendees as well.
Okay, so let's proceed to Mr. Ntazinda.
Yeah, thank you for the discussion. Thank you, ELS, for having us. My conclusion, I mean, let's, what my prayer is that we regulate, but as we promote. Basically, we should not put in place regulations that hinder or prohibit innovation, but would rather regulate on the usage, but encouraging innovation. So we should be up to speed with what is happening, but guiding it in the right discourse. I thank you so much.
Yes, so thank you so much, Mr. Ntazinda, for those concluding remarks in terms of the current topic. And indeed, it is notable that any laws developed by the different jurisdictions that we have when it comes to tackling those emerging effects that affect the IP right holders, those laws indeed should be captured in a way that they will not stifle, creativity, and they will still ensure that creatives can continue coming up with their respective innovations. So we move to Mr. Mkama to give us his parting shot. Over to you.
Thank you, Josephine. And my comment is, intellectual property is property like other property. It is like house, like car, and whatever property you know. Now, I always use this phrase, we dance according to the tune. So in this digital eras, it is the duty of the property owner, the owner of patent, the owner of copyright, the owner of trademark, to make sure that he goes or he dances according to the current trend to make sure that he protect his or our own IP rights. We can have laws, we can have mechanism, but if the rights, the owner of intellectual property is not ready to protect his or her rights according to the right, to the current trend of digital era, that one cannot work. So it is high and it is recommendable for each and every intellectual property owner to take the current globe, to understand the current globe and determine the current way on how he or she can protect his intellectual property right. Thank you.
Okay, so thank you so much for the parting shot that you've given us. Indeed, we have had a great session when it comes to the topic that we have considered today. So as we end this particular webinar, I think I'd like to just register my thanks to the various people who have been involved towards ensuring that this becomes a success. So I'd like to thank the East Africa Law Society for organizing this webinar. It has been really insightful because the participants present have been able to learn a thing or two when it comes to the emerging trends and how they're affecting the different IP right holders. I'd also like to thank our panelists who have been present with us today, making their presentations. So I would like to thank you, Mr. Pius Tanzinza. I would like to thank you, Ms. Eileen Naluso. I'd like to thank you, Mr. Mkama Kalebu. I'd also like to thank that is Professor Professor David Baki Binga in absentia. He was meant to join us previously so as to share the Ugandan perspective, but unfortunately, he could not join us today. But in the future webinars, I'm sure he'll be able to join us. I'd also like to thank the ELS Secretariat, Mr. Gabriel Akaye, who has also facilitated a smooth process in terms of making that sure that this particular webinar is a success. And lastly, but not least, I'd like to thank the attendees who have been present with us. You have been quite you have been, so patient in terms of listening in through all the presentations that have been tabled, and you have also engaged our panelists in ensuring that you keep posting those questions, which were so, mind-boggling and very informative. So I'd like to thank you, all of you. And as we, end this session, I will urge you to keep looking out on the ELS website and the social media platforms so that you can be able to see any other webinars that we have in place and maybe prepared for any other session. So thank you so much, and we can end this session at this juncture. So have a good evening. Bye.
Goodbye, and thank you for hosting, Josephine.